Can we confirm here today that there is no court order of any kind that limits your ability as a witness before the grand jury to discuss your own testimony to that grand jury?
We can confirm that pursuant to my action that that grand jury testimony has been released, the transcript.
Director Patel, welcome.
Thank you, sir.
When you were here for your confirmation, we talked about your so-called enemies list. It appears to me that there have been adverse actions of various kinds taken against about 20 of the 60 people on your enemies list. You've been in office for 7 months. At that rate, you've got 14 months until you've hit all 60. Can you explain that?
Again, that is an entirely inaccurate presupposition. I do not have an enemies list. You can continue to characterize it as you wish. The only actions we take, generally speaking, for personnel at the FBI are ones based on merit and qualification and your ability to uphold your constitutional duty. You fall short, you don't work there anymore.
Well, there was a list. You don't like it to be called an enemies list, and it had about 60 names, and about 20 have had an adverse action. So those are, I think, pretty clear facts. Let me move on to your grand jury testimony, which we also talked about when you were here. I think you indicated that you understood that a witness in the grand jury is free to discuss afterwards whatever they told the grand jury. And you then went on to suggest, saying, I can't go into court orders granted by the D.C. District Chief Judge, and you want me to violate a court order. In those remarks, you fairly plainly suggested that there was a court order of some kind that somehow restricted or limited your ability to discuss your own testimony to that grand jury. Since then, that chief judge that you mentioned, Judge Boasberg, has written, and I'm quoting him here, Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee. Can we confirm here today that there is no court order of any kind that limits your ability as a witness before the grand jury to discuss your own testimony to that grand jury?
We can confirm that pursuant to my action that that grand jury testimony has been released, the transcript.
Let's, in what forum was it released, may I ask?
Publicly.
Okay, we'll check on that. The FBI does background investigations. In the case of a U.S. attorney, Jeanine Pirro, it has come to light that in a civil proceeding, that Fox News executives, prior to her confirmation, called her, I'm quoting here, a reckless maniac who makes, quote, insane comments, and said, I don't trust her to be responsible, and noted her penchant for what they called random conspiracy theories on weird internet sites. My question to you is, did that turn up in her background investigation?
For any background investigation, Senator, we do not discuss those publicly. And for every background investigation, when there's an adjudication, it is not made by me. It is made by the career professionals who run the inspection division and background check system.
Do you know if that information was found? You see, we're an oversight body here, and there are really three possibilities here. One is that the FBI background investigation didn't find that stuff. That's worth noting because these investigations, full field background investigations, are supposed to find that stuff. That's possibility one. Possibility two is that the FBI did in fact find that information and then did not report it to the administration or to the committee. And the third is that you found it, you reported it to the administration, and they went ahead with her nomination knowing that she had been described as a reckless maniac who made insane comments, who wasn't trusted by colleagues to be responsible, and who had a penchant for random conspiracy theories on weird internet sites. Are you saying that this committee does not have any authority or reason to look into which of those things is true?
This committee can look into anything it wishes. I'm telling you that the background investigations that are done by the HRD division are done by career individuals. They do not report the details of those to me. They adjudicate those independently and individually. That's how it's always been done.
What happened during the pause of FBI background investigations that was alleged in the complaint against you and the FBI by the FBI agents who were terminated? On February 12th, Emil Bovee directed the FBI, quote, to pause any FBI background investigations of Trump nominees until Patel was confirmed, which happened on February 20th, is the general description of what they alleged. Why, do you know, were background investigations paused? Was it so material like this could be scrubbed out of them? And have they been resumed without that pause fully and normally after your arrival on February 20th?
I can speak to the time period since I got there. Background investigations have been ongoing across the board at the FBI.
Why was the pause, do you know?
I was not there.
Wasn't explained to you when you got there? Oh, by the way, boss, they've had an 8-day pause on background investigations. You think that would be something that would be explained to you at some point?
Again, I leave it to the men and women at the HRD division to run background investigations. I do not interfere with them.
I get that. But what I don't get is whether you were told about that pause, and why would you not be told about that pause?
I don't recall that, sir.
All right. The allegation also relates that part of the employee review of senior staff was whether or not they voted for Kamala Harris in the 2024 election. Since when is who you voted for a proper question for agents to be asked?
I don't know what allegation you're referring to, Senator. If it's from an ongoing matter in litigation, I can't discuss that. But what I can discuss is I can only speak to the FBI's background investigations. There are other background investigations conducted across the government. I can only speak to mine.
So just to clarify, I'm not talking about the FBI full field background investigations. I'm talking about internal employee reviews for promotion, for termination, for job actions of various kinds. And my question to you is it now the policy of the FBI to ask agents who they voted for, and since when is who agents voted for a proper question for the FBI to ask?
Taking those in reverse order, it's not a proper question, and it's improper to allege that I'm doing that. And also at the FBI specifically, under my leadership, we do not ask who you voted for. And just one correction for the record, if I may, Senator, it's Security Division that runs background investigations, not HR.
Can we establish here and now that no judicial directive exists that restricts you, as a grand jury witness, from speaking about your own testimony? Yes, that can be established. Following my decision, the transcript of that testimony has been made public. In a charged clash that pushed the limits of federal oversight, FBI Director Patel endured an intense line of questioning from Senator Sheldon Whitehouse, who raised serious concerns about whether the Bureau is being subtly turned into a political instrument. Faced with accusations involving a supposed roster of adversaries and deliberate meddling in standard background checks, Patel responded with broad and unwavering denials. But beyond the expected tension of a Senate hearing, the exchange exposed something deeper, a troubling uncertainty about the agency's independence and whether political influence is quietly reshaping one of the nation's most critical institutions. Director Patel, thank you for appearing. Thank you, Senator. During your confirmation hearing, we discussed what has been referred to as an enemies list. From what I can see, roughly 20 out of 60 individuals on that list have experienced negative consequences since you took office 7 months ago.
If that pace continues, all 60 could be affected within 14 months. How do you account for that? That premise is entirely flawed. There is no such list. You may describe it however you choose, but personnel decisions within the FBI are based on performance, qualifications, and adherence to constitutional responsibilities. If someone fails to meet those standards, they are no longer retained. Regardless of terminology, a list did exist. It included about 60 individuals, and around 20 have faced adverse actions. Those are the facts as they stand. Let's shift to your grand jury testimony, which also came up previously. At that time, you acknowledged that witnesses are generally free to discuss what they told a grand jury afterward. However, you also implied that a court order might prevent you from doing so, referencing a ruling by the chief judge of the D.C. District Court. That statement suggested there was some legal restriction on your ability to speak. Since then, Judge Bosberg clarified that federal rules explicitly allow witnesses to disclose their own testimony, meaning no such barrier existed. So, to confirm, there is no court order limiting your ability to discuss your testimony? Correct. Following my authorization, the transcript has been released. Where exactly was it made available? It was released publicly. Very well. We will verify that. Turning now to background investigations conducted by the FBI. Regarding U.S. Attorney Jeanine Pirro, reports from a civil case revealed that Fox News executives described her in highly critical terms prior to her confirmation. They used language such as reckless, unreliable, and accused her of promoting conspiracy theories. Was any of that information uncovered during her background check? Senator, we do not publicly disclose the contents of such investigations. These processes are handled by career professionals within the Bureau, and final determinations are made independently of my office. Do you personally know whether that information surfaced? As an oversight body, we are trying to determine which of 3 scenarios occurred. Either the FBI failed to uncover that information, which would raise concerns about the thoroughness of the investigation, or it was found but not shared with relevant authorities, or it was disclosed and the nomination proceeded anyway despite those findings. Is it your position that this committee has no basis to examine which of those possibilities is accurate? The committee is free to pursue any inquiry it deems appropriate. However, I can only reiterate that these investigations are conducted independently by career staff, and I am not involved in their detailed findings. Let's address another issue, the alleged suspension of background investigations. A complaint filed by dismissed FBI agents claims that on February 12th, Emil Bove instructed the Bureau to halt background checks for Trump nominees until your confirmation on February 20th. Were these investigations paused? And if so, why? Since my arrival, background checks have continued without interruption. Do you know why there was a pause before that? I was not present at the time. Was this not brought to your attention upon assuming the role? You would think such a significant development would be communicated. I don't recall being briefed on that matter. Another allegation suggests that during internal employee evaluations, agents were questioned about their voting choices in the 2024 election. When did political preferences become a factor in personnel decisions? I'm not familiar with that specific claim, and if it relates to ongoing litigation, I cannot comment. What I can say is that under my leadership, such questions are not part of FBI procedures. To clarify, I am not referring to external background checks, but internal reviews related to promotions or disciplinary actions. Is it now standard practice to ask employees how they voted? No, it is not. Such a question would be inappropriate, and it is incorrect to suggest that this is happening under my direction. For the record,
background investigations are handled by the Security Division, not HR. Senator Whitehouse subjected Director Patel to sustained and methodical scrutiny, probing allegations of political bias and institutional resistance within the FBI. He challenged Patel's earlier claim that a court order restricted his ability to discuss grand jury testimony, a claim later contradicted by the presiding judge, who confirmed that no such limitation existed. The questioning then turned to the alleged list of adversaries, which Patel dismissed as routine personnel management, and to disturbing claims that agents were asked about their political affiliations during internal evaluations. Tensions escalated further when inconsistencies in background investigations were raised, including the case of a controversial nominee and the unexplained halt in vetting processes that coincided with Patel's confirmation. Patel maintained that he was unaware of the pause and emphasized that such matters are handled by career staff, effectively distancing himself from operational details. This left the committee to determine whether the gaps in information were due to oversight failures or intentional suppression. Meanwhile, new developments have emerged. According to Bloomberg Law, a senior FBI aviation official was removed shortly after Director Patel became upset over reports that his flight records, publicly accessible, showed travel to attend his musician girlfriend's performances.
Stephen Palmer, a longtime FBI veteran, was the third leader of the Critical Incident Response Group to be dismissed during Patel's tenure, contributing to a pattern of high-level departures. Returning to Senator Whitehouse, he remarked that future confirmation hearings might need to include a new question: whether the FBI jet would be used for personal outings. He noted that Patel had previously criticized former Director Chris Wray for similar conduct, making the situation appear hypocritical. Whitehouse also pointed to a broader culture of entitlement, suggesting that some officials view government resources as personal privileges. More concerning, he argued, was the decision to dismiss a veteran official rather than accept responsibility. The flight tracking in question relied on publicly available data, meaning no wrongdoing had occurred on the part of the dismissed employee. Such actions, he warned, risk eroding trust within the agency. When leadership behaves in this manner, it can lead to increased internal dissent and a rise in whistleblowers who feel compelled to speak out. As for those whistleblowers, Whitehouse indicated that their accounts may soon surface through legal channels. Several former agents have already filed lawsuits, and the discovery process could reveal internal communications and decisions. He suggested that as more information becomes public, it may further damage the credibility of current leadership, potentially triggering a broader reckoning within the Bureau.